So over the next 15 minutes or so, I'm going to talk to you about my second favourite topic, which is a new learner protection scheme, soon to be established, how it will impact on you and your business, how it will benefit you, your learners, and the wider education and training sector as it becomes established. As part of the presentation, I will introduce you to some new terms associated with the scheme. But before I look at what is meant by protection of enrolled learners, I would like to clarify that when QQI refers to protection of enrolled learners, learner protection, or PEL, it is referring to the statutory scheme as provided for in the 2012 Act. The majority of English language providers are familiar with the term PEL in the context of the PEL criterion to be satisfied under the interim list of eligible programs for student immigration permissions. This is not a statutory arrangement, and as a non-statutory arrangement, this PEL requirement is less onerous than the statutory requirements of the 2012 Act, which in turn are more comprehensive. So what is learner protection? PEL for QQI is a legislative mechanism intended to ensure that a learner may complete their programme of choice irrespective of whether or not their chosen provider continues to provide the programme which they have commenced. What does protection of enrolled learners look like with the 2012 Act? So the 2012 Act provides for two types of arrangements or two types of bonding: academic bonding and financial bonding. With academic bonding, a learner affected by a programme cessation will transfer to another provider with a similar programme and complete their programme with that other provider. If programme completion is not possible, the learner will receive a refund of fees paid, and this is called financial bonding. As you can imagine, the legislation favours programme continuance or academic bonding over a refund of fees. So what are the limitations of the current PEL legislation? The implementation and operation of the provisions relating to PEL in both the 1999 and the 2012 Act have been problematic and challenging. The limitations include the following. In the first instance, academic bonding, where a learner continues their programme with another provider, as a preferred option, has not in general been achievable by providers, and there are a number of reasons for this. Financial bonding has been equally challenging, as the number and types of financial arrangements available for PEL purposes is relatively small. This is largely because many financial products don't satisfy the requirements of the legislation. And equally, a refund of the most recently paid fees is of little use to a learner who cannot complete their programme of study or who may not have evidence of credit achieved to date. The second issue with the current legislation is that QQI is obliged to assist learners to find similar programmes which will enable them to complete the education and training which they have commenced. But there is no provision to fund the cost associated with an intervention by QQI in the event of such a programme cessation. A further limitation is that the statutory PEL scheme under the 2012 Act only applies to programmes of 3 months duration or longer, and those that lead to a QQI award. It does not extend to education provision by English language providers or to providers offering programmes leading to awards of other awarding bodies that are on the National Framework of Qualifications. A significant number of college closures in recent times did not come within the statutory oversight of QQI, and these college closures have had a significant negative impact on the reputation of the wider education and training sector. So what are the features of the new legislation? The 2019 legislation recognises the shortcomings in the current legislation, and it provides for the establishment of a single national learner protection scheme underpinned by a learner protection fund. The new scheme applies to all providers and awarding bodies engaging with QQI directly and indirectly, including English language education providers that receive authorisation to use the IEM. The single scheme will therefore have a significantly expanded provider base to contribute to the National Learner Protection Fund. This will enhance confidence in the reputation of the wider education and training sector in Ireland. As with the current scheme, publicly funded education and training providers will continue to be exempt from the provisions. Unlike the current and previous schemes, the new Learner Protection Scheme is designed to ensure that there is a single Pell process for all learners, irrespective of their chosen provider and programme. All learners enrolled on a programme leading to a national award, QQI and other awards on the framework, and English language learners enrolled with providers that are authorised to use the IEM will therefore have equal protection, and that is really important. QQI will also have access to a ring-fenced fund that should enable it to deliver on its legislative remit to ensure that learners affected by a programme cessation may complete their programme and be certified in the original timeframe. The due diligence assessment of providers, which I spoke about earlier, will provide an important and robust underpinning to the National Learner Protection Fund. This should minimise the risk of QQI engaging with providers whose business model is not viable or sustainable in the context of the delivery of quality-assured education programmes. I will now look at some of the key aspects of the scheme. The first one being the Protected Programme Default Event. A Protected Programme Default Event occurs when a provider has accepted money from a learner and ceases to provide the programme for any reason, either before commencement or before programme completion. The provider concerned is required to notify QQI in writing of such an event, including details of the circumstances resulting in the cessation of the programme, details of the programme, and details of enrolled learners. The provider is also required to notify the learners in writing. An enrolled learner is obliged to accept any offer of an alternative similar programme by another provider. In general, a learner will have 30 days to accept the offer made, and after that time, the offer lapses. So what is an obligated provider? An obligated provider is a provider that is obliged to engage with the Learner Protection Fund. English language education providers authorised to use the IEM are one such category of obligated providers. Obligated providers shall in general pay an annual charge into the fund prior to commencement of the programme and prior to receipt of payments from the learners for enrolment onto a programme. An obligated provider will be required to provide QQI with information relevant to determining the amount of the annual charge, including information on fees, learner profile, and duration of the programme. Money received by an obligated provider more than 40 days before the commencement of provision must be lodged in an escrow account. This money cannot be drawn down until the programme commences, and if a programme does not commence for any reason, the learner will receive a refund of fees paid from the financial institution that holds the escrow account. This new provision will serve to protect the Learner Protection Fund. So what is the Learner Protection Fund and what are the reporting requirements? Ministerial regulations are required to underpin the establishment, maintenance and operation of the Learner Protection Fund. The fund itself will be operated by QQI. Obligated providers will pay an annual charge to the fund, and when a programme default event occurs, money in the funds may be used by QQI to pay the costs of programme completion by the learner in the original provider or in another provider with a similar programme. A refund of fees may be paid to a learner on receipt to submission from a learner indicating that the alternative arrangement proposed is not suitable. In all circumstances, QQI will endeavour to ensure that the learner may have a reasonable opportunity to complete a programme similar to that commenced in the original provider. QQI may seek to recover all costs borne by the fund from the provider that has ceased to provide the programme. This is intended to remove any perverse incentive for a provider to withdraw from a programme when the provider is not in financial difficulty. So, for example, in circumstances where a programme is loss-making due to lack of demand. QQI is required to prepare and publish a report on the operation of the fund annually. A 5-yearly review of the operation of the fund must also be undertaken by QQI. And this review will include submissions from providers to include the appropriateness of the annual charge in the context of the demand on the fund. The reports arising from these reviews must be published and submitted to the Minister for presentation to the Houses of the Oireachtas. And the annual charge, which I'm sure you're all interested in. The Minister will determine the annual charge to be prepared by each provider, and different amounts may be prescribed for different providers and different types of programmes. Factors to be considered when agreeing the annual charge include the provider category, the provider's size, the learner profile, number of international learners or domestic learners, programme fees, and the duration of the programme. So, for example, the annual charge levied on a provider with junior EU English language learners on a 2-week summer programme is likely to be less than the annual charge for a provider with adult international English learners on a 30-week programme. Equally, the charge for the latter is likely to be different to the charge paid by a provider with full-time learners pursuing an undergraduate programme. It is anticipated, however, that the annual charge to the fund will be low compared to current Pell costs. So when will the scheme apply? The new Learner Protection Scheme will apply immediately for all English language providers authorised to use the IEM. A transition period of a maximum of 3 years may be considered for existing statutory Pell arrangements only. This means that there will be a level playing field for all English language providers authorised to use the IEM regarding the cost and the nature of learning protection provided. Equally, it is clear that the introduction of the new national scheme will bring greater transparency, equity, and consistency to the issue of learner protection for learners. Standardised text for mandatory inclusion on an obligated provider's website will be provided by QQI, and this will describe the nature of the Pell scheme and the associated cost to the provider. The due diligence criteria that providers must satisfy before they engage with QQI should minimise the risk of QQI engaging with businesses which are not sustainable. This should reduce the number of programme default events and the need to draw on the Learner Protection Fund. And this in turn should reduce the level of the annual charge payable by obligated providers. The operation and management of the fund will involve the collection of a significant amount of information from providers in relation to its learners. The availability of specific information will be essential for the determination of the annual charge and the successful management of a programme default event. In this context, QQI is currently developing a process to collect data from its existing providers. It will also be gathering similar data from English language providers in the near future. Like other aspects of the 2019 amending legislation, it is clear that the new Learner Protection Scheme underpinned by the due diligence assessments of providers and applying to all providers engaging with QQI, will further enhance and protect the interest of learners and providers across all sectors of education and training. Access to a single and robust learner protection scheme that applies to a wide range of provision will give confidence to learners and the public, both nationally and internationally, in English language provision in Ireland. This will in turn enhance the reputation of your sector, which can only be a good thing for your business. Before I hand back to Mary, I would like to remind you that we will be drawing up an FAQ on all aspects of the new legislation, and therefore we would welcome any questions that you have for inclusion in this. We will continue to build on the FAQ until the commencement of the relevant legislation.